On April 4, 2011, the Obama administration's Education Department sent out what was known as the Dear Colleague letter. The Office for Civil Rights radically reinterpreted Title IX as giving the federal government the right to dictate the specific procedures that colleges and universities must use to adjudicate student-on-student sexual assault allegations. In 2014, while speaking at a summit on sexual assault at Dartmouth University, Catherine Lehman, the Assistant Secretary for Civil Rights in the Obama administration's Education Department, told the college administrators, "Do not think that this is an empty threat." What she was referring to by the empty threat was withholding federal funding from colleges and universities that did not follow the Obama administration's proposed guidelines on how to handle sexual assault cases. The American Council on Education observed that college grievance and disciplinary procedures were meant to address academic misconduct, not serious criminal allegations like sexual assault. The Department of Education nevertheless forced colleges and universities to employ a kangaroo court system in sexual assault cases that denied accused students basic due process rights. Unbelievably, many colleges and universities, including the University of Pennsylvania and Middlebury College, train their Title IX investigators and adjudicators to start by believing the alleged victim. In other words, the accused student in these college and university investigations and adjudications is presumed guilty, not presumed innocent, presumed guilty. Many colleges deny the accused student access to the complaint filed against them, the evidence against them, the identities of witnesses, and cross-examination of their accusers. This is the same type of system that Joseph Stalin used in the 1930s when he put on hundreds of show trials to purge his political enemies. Some colleges actually tried to do the right thing. In one case, Princeton University used a clear and persuasive standard of proof, which is a higher standard than the preponderance of evidence standard proposed by the Obama administration. Under pressure from the Obama Office of Civil Rights, Princeton changed its standard to preponderance and banned cross-examination. The result was predictable. Male students began suing universities that were railroading them into sexual assault convictions. Since 2011, more than 400 students accused of sexual assault have sued their university. Almost 200 of those students have received favorable rulings. In a notable recent case, a male student sued Pomona College alleging that Pomona had denied him a fair hearing by refusing to allow him to cross-examine the alleged victim. Los Angeles Superior Court Judge Mary Strobel ruled in the student's favor, holding that Title IX proceedings that are not fair to accused students violate the public interest. Judge Strobel ruled that Pomona College had to pay the accused students attorney's fees, which could be up to $250,000. In November 2017, the new Secretary of Education, Betsy DeVos, rescinded the Obama Title IX procedures. This caused a firestorm of criticism. A special interest group funded by President Obama and Vice President Biden created an anti-DeVos video.
This holiday season, Betsy DeVos sent a lovely gift to the students of America.
The multimedia
new Title IX
marketplace.
guidelines. Here's a little story about it. Entitled, One Gift by Betsy DeVos. Late one evening at the Department of Ed, thought around Betsy DeVos's head. She needed a gift, she started to think. A present for the people that would really stink.
The DeVos standards require common sense due process protections such as the right to counsel, the right to cross-examine your accuser, and the right to a hearing. The DeVos proposed regulations have been called sensible and necessary by such notable authorities as Harvard Law professor Jeannie Suk Gerson and many of her academic colleagues. The history of Title IX since 2011 teaches one thing. The federal government under the Department of Education is requiring colleges and universities to deny students who are accused of sexual assault basic due process rights. If you have been accused of sexual assault on a college campus, the only way to force your college to treat you fairly is to have an experienced lawyer protecting your rights and keeping the college honest with the threat of litigation.